Welcome to the Explainer. So, you're trying to wrap your head around the complex world of U.S. immigration, right? Well, you are definitely in the right place. Today, we're going to unpack exactly what family-based petitions are, the absolute nuts and bolts of how they work, and what it actually looks like to navigate them in the rapidly shifting policy landscape of 2026.
How long does it really take to sponsor a family member for a U.S. green card? Honestly, I hear this question all the time. And the answer? Well, it's incredibly complicated. See, there's this massive gap between the simple idea of just filing a petition to bring a relative over and the harsh, on-the-ground reality of the wait times involved. We're going to bridge that gap today, so you know exactly what applicants are actually facing.
Okay, let's dive right into this. Here is our roadmap for today. First, what is a family petition? Second, the two different queues. Third, understanding the visa bulletin. Fourth, the 2026 operational realities. And fifth, consular processing versus adjustment.
All right, Section 1. What is a family petition? Let's look at the administrative engine behind it all.
At its very core, a family-based petition relies on one absolutely critical document, Form I-130, which is officially known as the Petition for Alien Relative. Think of this as the ultimate starting line. It's the administrative vehicle that legally establishes a qualifying relationship between a petitioner, so usually a U.S. citizen or a permanent resident, and a beneficiary, the family member who wants to immigrate. You have to definitively prove on paper that you're related and that your specific relationship actually qualifies under U.S. law.
Let's ground this with the basic timeline before we get into the heavy jargon. Step 1, you file that Form I-130. Step 2, you enter the waiting period for visa availability and processing through the National Visa Center. And Step 3, the finish line. That's either an interview abroad or adjusting status inside the U.S. 3 basic steps. Sounds pretty straightforward, right? Well, let's see how this builds into something a whole lot more complex.
Moving to Section 2, the two different queues, and why wait times vary so drastically.
So, the immigration system is essentially split into two parallel lines. Think of it like a VIP FastPass line versus a limited-capacity waiting room. On one side, we have immediate relatives. This means spouses, parents, and unmarried minor children of U.S. citizens. For them, there are 0 annual visa limits. You file, and the I-130 is generally processed in about 10 to 18 months. But then, on the other side, we have the family preference categories. This includes adult children, siblings, and relatives of green card holders. If you are in this queue, you are subject to strict annual limits and, as a result, some truly massive backlogs.
And here is the magic, or maybe not so magic number, 226,000. Every single year, only 226,000 visas are handed out globally across all those preference categories. This explains exactly why that second queue moves at an agonizing crawl. There is simply way more demand than the legally permitted supply.
Part 3. Understanding the visa bulletin, essentially the government's waiting list.
So how do families actually know where they stand in this giant waiting room? The Department of State publishes this document, the Visa Bulletin, every single month. It publicly announces whose priority date, which is basically your ticket number in line, is finally up to get a visa.
Now look closely at these June 2026 numbers. Specifically, check out the F3 category for Mexico. These are the married children of U.S. citizens. Check out that final action date, May 1, 2001. Yeah, you saw that right. That is a staggering 25-year wait. A U.S. citizen who filed an I-130 for their married child in Mexico way back in 2001 is only just now reaching the front of the line. It's a really jarring reality check of just how backlogged the preference system has become over the decades.
Which brings us to Section 4, the 2026 operational realities and navigating this new policy landscape. First up, right out of the gate, there's a new financial hurdle, $250. This is the brand new Visa Integrity Fee introduced by the sweeping One Big Beautiful Bill Act, or OBBB, which took effect in 2026. It adds an entirely new cost on top of the already existing filing fees, meaning it's just objectively more expensive to initiate these petitions now. But look, we're talking about more than just fees here. We are seeing a fundamental shift from statutory entitlements to high-stakes administrative discretion. OBBI-SC centralizes funding directly toward enforcement. We also have an interim final rule from the Board of Immigration Appeals that essentially creates an environment of default summary dismissals, totally changing how appeals work. Plus, there's a new $100 recurring annual fee just to keep an asylum application pending. And USCIS has been directed to pause and re-review applications from 19 designated high-risk countries. Now, regardless of where you fall on the political spectrum, the objective reality for practitioners and families is that the system is tightening up and becoming significantly more demanding. And you know, these systemic delays have profound, very real human consequences. Take a look at a recent 2026 precedent, Matter of Aravello Vargas. It clarified that children who reach the age of 21 while stuck in a multi-year appellate backlog essentially age out. They legally lose their status as qualifying relatives. This creates a terrifying race against the clock for families. The legal waiting game can literally age a child out of their only chance to stay with their parents.
Finally, Section 5, Consular Processing versus Adjustment, the final hurdle to the green card.
So, you've waited all these years. How do you actually finish the process? Well, there's a huge mechanical difference here. Adjustment of status, or AOS, happens using Form I-485 applied from inside the United States. The beneficiary doesn't have to leave the country at all. Consular processing, on the flip side, means you have to travel internationally and interview at a U.S. embassy or consulate abroad. For families already living in the U.S., leaving for consular processing can trigger devastating multi-year bans on returning, which makes adjustment of status highly, highly preferred.
But here is a massive update for 2026. A recent USCIS memo from May has officially reframed domestic adjustment of status. It's no longer seen as a standard procedure, it's now considered an extraordinary form of relief based on administrative grace. The era of routine adjustment? It's over. Now, applicants have to proactively and affirmatively prove they deserve it by documenting positive equities. We're talking things like extreme hardship to U.S. relatives, spotless tax history, and really deep community ties.
And what if you are forced to go the consular processing route? Will 2026 introduce some intense physical and geopolitical hurdles there too? A January presidential proclamation fully or partially suspended visa issuance for 39 countries. On top of that, the State Department is implementing an African consular hub model, which closes nearly 30 embassies across the continent. So, for example, if a family member is in Algeria, they might now be required to physically travel across borders to a regional hub in Nigeria just to have their interview. The government is essentially turning this default to consular processing into a secondary border.
So to wrap up this explainer, I want to leave you with this one crucial question to think about. In a system that is increasingly defined by 25-year backlogs, tightening administrative discretion, and mounting financial and physical barriers, how will families successfully navigate the path to reunification in 2026 and beyond? Thank you so much for joining me today to demystify family-based petitions. Keep learning, keep questioning, and I'll catch you on the next explainer.